Hello viewers and a warm welcome to this episode of the Indian Lawyer Legal Tips. Today's topic is going to be a comprehensive overview of a civil trial. This is going to be of great importance to new entrants in the field of law as well as prospective clients. I am Sushila Varma, Advocate and Chief Consultant at the firm. Let us begin with how a civil trial takes place in India. Generally, a civil trial is a legal process that is followed by courts to adjudicate disputes of a civil nature. This could be property disputes, disputes pertaining to recovery of money, matrimonial issues, personal issues, and also contractual disputes. Essentially, all these kinds of disputes have to be civil in nature. That is, they should not have the element of criminal law. All these civil trials will have to be conducted under a law which is known as the Civil Procedure Code 1908, which deals with the entire process from institution of a suit till pronunciation of judgment. Now, how does a suit get instituted? A civil suit is initiated by filing of a plaint which is prescribed in Order 4, Rule 1 of the CPC. The plaint is a written statement in which the plaintiff pleads all the facts that are important for proving his case. This has to be supported with an affidavit in which he or she has to swear that the facts that have been pleaded are true and correct. The plaint forms the basis of the case, and hence it is extremely important that all facts which will help you to prove your case must be taken at the inception. The plaint also has to have all the documents that one is relying upon when one is filing a plaint. Please note that when you are filing an original suit in a civil case, you must keep in mind that you are within the law of limitation and that the jurisdiction of the court is correct. Now let me explain what I mean when I say jurisdiction. Jurisdiction is three types in nature. The first is subject matter jurisdiction, which means that the court has the power to decide on that particular subject. For instance, if it's pertaining to a property, then it should be that the court which you have approached has the power to look into property disputes. Secondly, territorial, that is, the dispute must have taken place within the territory of that particular court. And finally, the pecuniary jurisdiction, which refers to the financial valuation of the claim and whether the court has the power to adjudicate the case. This pecuniary jurisdiction and the value of the suit also helps one to determine what is the court fees one has to pay. Dear viewers, please note that the place of suing always has to be the lowest grade court competent to try it. That is, you cannot go rushing off to higher courts when the law demands that any case which is instituted must be instituted in the court of the lowest grade competent to try it. This is regulated as per the provisions of the Civil Procedure Code. Now, regarding the plaint, as already explained earlier, must contain specific details. It should also have details such as the name of the court, particulars of the plaintiff, the defendant, the facts that constitute the cause of action, jurisdictional facts, relief claimed, and of course, valuation of the suit so that the court fees can be determined. Since 1999, it is now mandatory to support a plaint with an affidavit in which the plaintiff states that all the facts that have been given are true and correct and that a false or frivolous litigation has not been filed. In the event that one files a false statement in pleadings, this can lead to prosecution for perjury. Now, what happens after the plaint is admitted? The first step is obviously to issue summons to the defendant. The court directs the plaintiff to submit multiple copies of the plaint depending on the number of defendants, along with the necessary fee, which is known as process fee for the service of summons. The summons serve as a formal notice to the defendant informing him or her that a case has been filed in a particular court of law and that he or she has to appear before the court. The court must be vigilant in ensuring that summons are issued and served promptly, as delayed in the service can prolong the trial unnecessarily. Once the summons is served, the defendant is required to appear before the court and file a written statement as per Order 8, Rule 1. The written statement is the defendant's response to the allegations made in the plaint and must be filed within 30 days from the date of the service of the summons. However, in exceptional circumstances, the court may grant an extension for allowing the written statement to be filed, and this extension can be till a period of 90 days. If the defendant fails to file a written statement within the stipulated period, the court can then proceed ex parte and decide the case in favor of the plaintiff. The defendant, while submitting his or her written statement, has to also submit all documents upon which their defense is based. The defendant is required to file a list of documents that he or she is relying upon along with the statement. If a document is not in the defendant's possession, they can disclose the name of the person who holds it and request the court to give permission that the other party who is holding the document produce it. Now, when the defendant is filing their written statement, there is a possibility that the defendant may want to claim for a set-off or counterclaim. In cases where the defendant has a legal claim against the plaintiff, they can file a set-off or counterclaim under Order 8, Rule 6 and 6A. A set-off is a claim for a certain sum of money legally recoverable which the defendant seeks to deduct from the plaintiff's claim, whereas a counterclaim is an independent claim that the defendant can raise against the plaintiff in the same suit, provided it arises from the same transaction or cause of action. Awareness of the laws is something that will help many litigants to decide whether or not they would like to file a case, because sometimes a case can be decided by the process of mediation or out of court, which in my opinion is the best way to solve a dispute. If you have found this episode useful, please like, share and subscribe. We would also request you to please share it with as many people as you can so that we can have a better outreach and share our legal knowledge with as many people as we can. Thank you for watching this episode, and we shall come to you with another episode on criminal trials. Till then, namaste.